Judgment in the matter of Potanina against Potanin.
Lord Legate will explain the decision of the court.
This appeal raises a question about the right of a party to legal proceedings to be heard before a court makes a decision against that party. The question arises in proceedings under Part 3 of the Matrimonial and Family Proceedings Act 1984. This Act gives courts in England and Wales power to grant financial remedies to a divorced spouse after an overseas divorce. Before granting a remedy, the court has to consider whether it would be appropriate for a court in England and Wales to do so, having regard to a list of factors. These factors include the extent of the parties' connections with England and Wales, with the country in which they were divorced, and with any other country. The Act also says that no application for a financial remedy may be made unless the permission of the court has been obtained in accordance with rules of court, and that the court must not grant permission unless it considers that there is, quote, substantial ground for claiming a financial remedy in England. The parties to this case are both Russian citizens who had both lived in Russia all their lives until the wife took up residence in London after their divorce. The husband still lives in Russia. They were both born in Russia in 1961, were married in Russia in 1983, and their marriage was dissolved by a Russian court in 2014. Initially, the couple were not well off, but since the 1990s, the husband has accumulated vast wealth. Their divorce was followed by extensive litigation in the Russian courts about the division of their assets. The final outcome of this litigation was that the wife received half the value of the assets which her husband owned. But the award left out of account most of the wealth accumulated by the husband, which is held in various trusts and companies. Those assets were not regarded by the Russian courts as marital assets. The wife is seeking to pursue a claim for further financial remedies in England. Immediately after the couple were divorced, she obtained a UK investor visa and bought a flat in London. Since 2017, she has been habitually resident in England. In 2018, she applied for permission to seek a financial remedy in the English courts. The rules of court say that such an application must be made without giving notice to the former spouse unless the court directs that notice is to be given. If the application is heard without giving notice and is granted, the court order must then be served on the former spouse. The rules of court give a party who is served with an order made without notice to them the right to then apply to the court to set aside or vary the order. In this case, the wife's application for permission to claim a financial remedy in England was heard without notice to the husband. After therefore hearing argument only from the wife's legal representatives, the judge granted permission. The court's order was then served on the husband, and he applied to have the order set aside. A hearing then took place at which both sides were represented. After hearing argument from both sides, the judge decided that he had been materially misled by the wife's representatives at the first hearing, held in the husband's absence. He also decided, after hearing argument from both sides, that the test for granting permission was not met, mainly because the connection of the parties with Russia was infinitely greater than their connection with England and Wales. So the judge set aside his original order and refused permission for the wife to claim a financial remedy in England. The wife appealed to the Court of Appeal. The Court of Appeal took the law to be that the judge was not entitled to set aside his original order unless there was a, quote, compelling reason to do so. And this in practice meant only if he'd been materially misled by the applicant. Furthermore, it had to be possible to demonstrate this by way of a, quote, knockout blow. The Court of Appeal decided that on the facts of this case, the judge had not been misled by the wife's counsel in any way that was material to his decision. That meant that the judge had been wrong to give the husband a chance to argue that permission should not be granted, and wrong, after hearing such argument, to set aside the order he had made after hearing from the wife alone. The Court of Appeal therefore restored the judge's original order, which had given the wife permission to claim a financial remedy in England. From that decision, the husband has appealed to the Supreme Court. By a majority of 3 to 2, the Court allows the appeal. The reasons for doing so are explained in detail in my judgment. But the main reason is very simple. It is an absolutely basic rule for any judge dealing with a case that before making an order requested by one party, the judge must give the other party a chance to object. Sometimes a decision needs to be made before it is practicable to do this. Then the judge must do the next best thing, which is, if the judge makes the order sought, to give the other party an opportunity to argue that the order should be set aside or varied. What is always unfair is to make a final order, only capable of correction on an appeal, after hearing only from the party who wants you to make the order, and without allowing the other party to say why the order should not be made. This case illustrates the unhappy consequences of dispensing with this fundamental rule of procedural fairness. The effect of the Court of Appeal's decision was that because the husband could not demonstrate by a knockout blow that the judge had been materially misled at the initial hearing, held without his knowing about it, the husband had no right at all to be heard on the question whether permission should be granted to the wife, and the judge was not entitled to set aside or alter the order made after hearing argument only from the wife's counsel. This in turn meant that the judge's original order granting permission was restored, despite the fact that after hearing argument from both sides, the judge had reached the considered view, for which he gave detailed reasons, that the test for granting permission was not satisfied. The law does not require this approach. Not only is it contrary to basic procedural fairness, but it is also inconsistent with both the words and the purpose of the relevant rules of court. As I've mentioned already, the rules give a party served with an order made without notice to him the right, that is the word used, to apply to have the order set aside or varied. This right is unconditional. There's no requirement to show a compelling reason or to show that the court was materially misled by the applicant before the right may be exercised, let alone to have to demonstrate this by a so-called knockout blow. The source of these supposed requirements is some remarks made in a judgment of this court in 2010, which the Court of Appeal subsequently endorsed. The remarks were and are not binding, as the procedure for dealing with permission applications was not in issue in those cases, and the court heard no argument about it. What is more, the rules of court to which I've just referred did not exist when the remarks were made. And as explained in detail in my judgment, the approach recommended was based on a misreading of what had been said in some earlier cases, and on an incorrect analogy with the procedure for dealing with applications for permission to appeal to the Court of Appeal. On this appeal, the proper way of dealing with applications for permission to claim a financial remedy in England is squarely an issue and has been the subject of full argument. We conclude that if a judge grants permission after hearing from the applicant alone, the other party has an absolute right to apply to have the order granting permission set aside. At the hearing of that application, the court is required to decide afresh, after hearing argument from both parties, whether the test for granting permission is met. If the judge decides that the test is not met, then the judge is both entitled and obliged to set aside the initial order and to refuse permission. Two members of the court disagree with that conclusion for reasons given by Lord Briggs. I cannot summarise his judgment properly in these brief remarks, but key points made are that the current practice was established in 2010 by unanimous, albeit non-binding, guidance given by the Supreme Court, and shortly afterwards endorsed by the Court of Appeal, and has since been consistently applied. The Supreme Court does not normally intervene in matters of practice, and in the view of the two dissenting justices, the Supreme Court should in this case leave it to the Family Procedure Rule Committee to decide whether the current regime needs reform. The main reasons why the majority of us do not think it right to leave the matter to the Rule Committee are first that there is no need to change the rules. As I've explained, the rules of court already give a party on whom an order made without notice is served the right to have the order reconsidered at a hearing at which both parties are present. What is needed is to apply the rules as they stand and not to disregard them. Second, the current practice is unlawful, as it is contrary both to the rules of court and to a fundamental principle of procedural fairness. In our view, it is a matter of public importance that courts at all levels should respect this fundamental principle, and that this court should intervene to end a practice that conspicuously fails to do so.
The court will adjourn.